So Senator Natasha akpoti-uduaghan has been arraigned before the Federal High Court sitting in Abuja for the second time. This will be the second trial in less than 2 weeks. Recall that she was first arraigned before the FCT High Court about 2 weeks ago, and in this very charge, she has been taken before the Federal High Court sitting in Abuja. This is Senator Natasha Akpoti. This is the husband, High Chief Emmanuel Uduaghan, and this is Aisha Yusuf, and these are other persons sitting, obviously accompanying Senator Natasha, to the court. A day before the charge, Senator Natasha had posted on her verified page. She said, preparing my look for the second Federal High Court of Nigeria's, Federal Government of Nigeria's case against me, filed on behalf of Senator Godswill Akpabio and ex-governor Yahaya Bello, coming up tomorrow, the 30th day of June, 2025, at the Federal High Court, Abuja, court number 5 by 9 a.m. And this is what she posted, just making light of the situation. And this is Senator Natasha akpoti-uduaghan. We all know her. And the question is, what is the charge against Senator Natasha akpoti-uduaghan at the Federal High Court sitting in Abuja? Right? This very count has to do with Senator Godswill Akpabio. This other count has to do with Governor Yahaya Bello, former governor of Natasha's home state, right? And what does it say? It says that on or about the first day of April 2025, while addressing a crowd of people in Ihima community in Kogi State, that you, Senator Natasha akpoti-uduaghan, intentionally caused the following communication to be transmitted via a computer system and network to it, that you said that Senator Godswill Akpabio told Governor Yahaya Bello that he should make sure that Natasha is killed in Kogi, not in Abuja, so that it seems as if it is the people in Kogi that killed her. And so the charge goes on to say that Senator Natasha akpoti-uduaghan knew that this statement that she made on this very day contained a threat that could harm the reputation of Senator Godswill Akpabio, Senate President of the Federal Republic of Nigeria, and that for that reason she has committed an offense against Section 24, Sub 2 of the Cybercrimes Prohibition and Prevention Act 2024. It is the same charge here, right? It's the same language, but the difference here is that this one talks about Godswill Akpabio, this one talks about Yahaya Bello. So the charge simply says that Senator Natasha akpoti-uduaghan, you remember the address she had when she flew via the helicopter and entered into her community. Remember the statement she made that day. So that statement is why the federal government of Nigeria has gone to the court against Senator Natasha akpoti-uduaghan, and the charge is saying that the communication she had that day, which was transmitted via electronic network, namely Channels Television, that statement that was said that day is contrary to the law, and that it had the propensity of lowering the image and reputation of Senator Godswill Akpabio and that of Governor Yahaya Bello. By implication, she is charged for criminal defamation of the character of these two persons under the Cyber Crimes Prohibition and Prevention Act, Laws of the Federation of Nigeria 2004. Now, what says Section 24 of the Cyber Crimes Act, the section that Senator Natasha Akpoti has been charged before the court? This is the Cyber Crimes Act. It was passed into law by the National Assembly of Nigeria in 2015 and has been amended in 2024, just recently under this administration. What does this act say? Section 24 of the act. Recall that it was first enacted in 2015 and has been amended in 2024 by the current president of the Federal Republic of Nigeria. And this is the amendment, okay? You see here, amendment of section 24 of the Principal Act. It's been amended to include words like pornographic or he knows to be false for the purpose of causing breakdown of law and order, posing a threat to life, or causing such message, to be sent. If you read it as a whole, it says, a person who knowingly or intentionally sends a message or other matter by means of computer systems or network. Remember the church talked about computer systems and network. Okay? If you send and you know that that statement that you have sent is grossly offensive, pornographic, or is of an indecent, obscene, or menacing character, or causes any such message or matter to be sent, or he knows it to be false for the purpose of causing annoyance, inconvenience, danger, obstruction, insult, injury, criminal intimidation, enmity, hatred, ill will, or needless anxiety to another, or causes such a message to be sent, is guilty of an offense under this act and is liable on conviction to a fine of not more than 7 million naira or imprisonment for a term of not more than 3 years or both. Simply said, this act says if you cause the transmission of a statement that is false, that also has the propensity of causing a breakdown of law and order and poses a threat to life or causes such message that will cause anxiety and destroy the reputation of another, you are guilty of an offense. And by this section, if you are found guilty, the fine is 7 million naira. So you can be asked to pay the fine alone or fine and imprisonment for 3 years. So this is basically what Senator Natasha akpoti-uduaghan has been taken to the court for under the present, charge. Remember that the first charge that she was taken to the court was for offense said to be against the penal code. This one is for offense said to be against the Cyber Crimes Prevention Act. This Cyber Crimes Prevention Act was signed into law by the Senate on the 21st day of December 2023 and signed by the House of Reps on 14th February 2024. After that, it was signed by the clerk of the National Assembly on 27th February 2024 and by the president on the 28th day of February 2024. So it's a very new law, very new amendment. This is the President of the Federal Republic of Nigeria. It is during his regime that this law has been amended. Now, what is needed of the prosecution in this case? This is a Federal Minister of Justice. It is a Federal Minister of Justice that is taking up this charge against Senator Natasha. The Federal Minister of Justice is headed by the Attorney General of the Federation. What is expected of the prosecution in this case? People would ask. This is a criminal allegation, and the proof is beyond reasonable doubt. If you prove and you leave some doubt, Natasha is set free. So what the law requires to secure a sentence against Senator Natasha, a holding against Senator Natasha, is that you must prove the allegation beyond reasonable doubts. Any doubts created by the prosecution will make Senator Natasha to go home because the court cannot convict or cannot find anybody guilty until the charge has been proved beyond reasonable doubt. So the publication that is said to have been made by Senator Natasha must be proved. Evidence must be tendered before the court to say that truly it is Senator Natasha akpoti-uduaghan that made this publication and that the publication is such that can be tendered before the court and marked as evidence. Witnesses will have to be called. After the prosecution is done, Natasha will have to do one of two things. Note, after the prosecution is done, calling witnesses, tendering evidence, Natasha would have to do one of two things. Number one, it is either she enters a no-case submission and says, "My Lord, I have listened to the case of the prosecution. The ingredients of this offense has not been proved against me as required by law. My Lord, let me go." If that succeeds at no case submission, she doesn't even need to enter the witness box and testify in her defense. If the court finds that the no case submission has been proved, then she will be acquitted and discharged. No case submission is one of the it's one of the defenses available for every accused person in criminal trial under our legal system. The second option she has is to enter into her defense. If she sees that, well, the prosecution has said something, and I don't want to waste my time with no case submission, she goes straight into the defense, of the matter. And that is why I said that she has the option to do one of two things. Now, this is Senator Natasha akpoti-uduaghan. This is High Chief Emmanuel. This is Senator Natasha. This is her lawyer, obviously. And Aisha Yusuf here. Lots of cameras, the paparazzi everywhere in the courtroom. And this is her lawyers. When you see this, you see that this is a senior advocate. When you see this at the back, right, that is only worn by senior advocate, the prince. A senior advocate is a prince of the bar, right? So that cloth is only worn by the senior advocate. It's the same wig and gown, but when you look close by, okay, when you look closely, for us lawyers, we'll see that, okay, this one is a senior advocate because of the distinction in the gown that he is wearing. So Natasha has a duty to defend herself with evidence. Note, she has a duty to defend herself with evidence. Now, what is she expected to do to show that she did not make the statement? If she did not make this statement, she has a duty to show to the court that she did not make the statement. That's a defense. Or that she did not say it as reported. She could say it's edited. She could say it's doctored. She could say that's not exactly what she said, and then present the one that she said. That's still a defense for her. Or that she made the statement and that she stands by it because it is true. Okay? That would mean that she would tender evidence to show that there was a meeting between Senator Godswill Akpabio and Governor Yahaya Bello, or there was a phone communication between these two persons, and that what they said was that she should be assassinated, not in Abuja, but in Kogi State, so that it will look as if the assassins are from Kogi State and not from anywhere else. If she has that evidence to present to the courts, that's a complete defense in law. If she has that evidence, right, the law is a truth. It's a total defense in a charge of criminal defamation. You said that somebody is a criminal. The person takes you to court. And you have a judgment that was decided in 1902, which convicted the person. That means the person is a criminal. You tender it before the court, you are completely exonerated because there is evidence to show that the person is a criminal. So, if Senator Natasha akpoti-uduaghan has the evidence to support the statement she made against Akpabio and against Governor Yahaya Bello, and she tenders that before the court of law where she's standing trial, that is a complete defense, and she will be completely exonerated of the charge because truth is a defense, a total defense in the charge of defamation of character. Now, what if she has no defense? So when we talk about one side, we also talk about the other side. We talk about the fact that she will have. We also talk about the fact that it is possible she doesn't have. So what if she doesn't have any defense? That would be too bad of Senator Natasha. If she has no defense whatsoever to support the allegation that she made on international TV, that will be too bad of distinguished Senator Natasha. Natasha is not just a senator, she's also a lawyer. She was called to bar in 2005. 2005. This is 2025. So that means that Senator Natasha is a lawyer of 20 years. A lawyer of 20 years understands the law very well. So if Senator Natasha akpoti-uduaghan does not have evidence to support her allegation, that would be too bad. She would then have to pay for it if she has no evidence. How do you pay for it in a criminal trial? You stand convicted. You stand sentenced. And the sentence in this case is, if you are found guilty, you'll be asked to pay a fine of 7 million naira, or you pay a fine of 7 million naira and still go to jail for not more than 3 years. This is too much for anybody that has political future and political ambition. Anybody of her status, it is too much. But what do I think? The best would be to have evidence. That is what I think. The best in the situation for Senator Natasha akpoti-uduaghan would be for her to have solid and substantial evidence. I don't want to believe she doesn't have evidence. The trial is just unfolding, right? Now, Senator Natasha was granted bail on self-recognizance. If you followed me in my last video, where I talked about why Senator Natasha was granted bail, I did talk about the fact that she ought to have been granted bail on self-recognizance. I said she's qualified to be granted bail on self-recognizance. Today, in this very charge, the judge has granted her bail on self-recognizance. What does it mean? It simply means that she is granted bail without a surety. No surety. No, bring a senator as a surety who has landed property in Abuja. The property, the surety is to pay 100 million naira or 50 million naira, as was said the other time. It simply means go home. I trust that you are not going to run away from justice. I trust that you will be available to stand this trial. For that reason, go home on self-recognizance. It is allowed in law, right? This is usually because of the person's status and integrity in society and the unlikelihood of the person escaping trial. This is Senator Natasha akpoti. This is Senate, Federal Republic of Nigeria. This is her office. Where is she running to? She's not going to run. There's that likelihood that she's not going to run. There are many reasons why she would not run. I think it is for those reasons that the judge simply said, go home, come back to the court on the next day. Nobody needs to take you on bail. Now she has a duty to keep to the terms, the usual terms of the bail. You don't jump bail. You don't stay back from court on the day of trial. So she's expected to be in court every day the matter comes up, because it's a criminal trial. It is only on civil matters that the lawyer can defend you in your absence. This one, you must be in court with your lawyer. Senator Natasha understands that, because she is not just a senator, but she is a senior lawyer of 20 years standing. That's a big thing in law, right? Now, why is she tried in 2 courts? This is Senator Natasha. That's a question a lot of people are asking. So why is she tried in 2 courts by the same office of the Federal Attorney General? Why? Why not try her in 1 court? Let's try some explanation. Offenses under the penal code, the one that she was tried before today, can only be tried in a state high court. That is why she was tried before the Federal Capital Territory High Court. Federal Capital Territory is taken to be a state. So that is why she was tried before the FCT High Court, Abuja, for offenses said to have been against the provisions of the penal code. Right? You cannot try penal code offenses in the Federal High Court. In this very charge, she is taken to the court against the provisions of the Cyber Crimes Act. Now, offenses under the Cyber Crimes Act can only be tried at the Federal High Court. Right? That is why she has been taken today before the court for the offenses said to have been committed against the act. Right? Now note, the law allows the prosecution to choose from one of the laws. The Federal Attorney General has the power to prosecute in every court. So the law allows the Federal Attorney General, or the Office of the Federal Attorney General, to look at the offenses together, the offenses look similar. It's still about criminal defamation of character, pursuant to this law, pursuant to this law. The content is almost the same, right? Even though they were made on different occasions. One was on one of the TV stations live. The other one was while she was in Kogi State. So the law would have expected that the Federal Attorney General would look at these offenses together and bring them together under one charge before one court, so that she will all just be appearing in one court. Everything, count 1, count 2, count 3, count 4, count 5, everything together in one charge and taken before one court, so as not to be too stressful for her. However, the law also does not prohibit the Federal Attorney General from charging her to different courts depending on the law providing for the offenses that she has been arraigned in courts. The law does not prohibit the Federal Attorney General. But if you ask me what I would have done, or what I would have instructed the officers in my office to do if I were to be the Federal Attorney General, I would have said, carry all the allegations, take it under one law. Both laws still have punishments. Take it under one law and go to one court and try her there. But note, like I said, the Federal Attorney General has not offended any law by going to this court and also going to this court. But it's certainly going to be stressful for Senator Natasha and more expensive because different lawyers, at the different courts, right? Now, what do Nigerian citizens want? This is Senator Natasha. What do Nigerian citizens want from this charge? Both courts. We want speedy trial. Everybody wants speedy trial. I did say the other time that justice is a three-way traffic. Three-way traffic. Courtesy of Honorable Justice Chukwudufe Oputa, father to Charlie Boy Oputa. He said justice is a three-way traffic. Justice for the victim of the crime, justice for the accused person, and justice for society. These three persons, accused, the victim, and society, everybody's interested in this matter. We want it to be tried expeditiously so that Nigerians will know the verdict of the court as soon as possible. Many thanks.